Hi, I'm here today with Lily Harwood from ICA. My name's David Robson. I'm the Senior Manager from Content and Development at ICT. We thought it was about time for another video blog from ICT. And so I'm here today to talk to you about a particular case study that we've been using in the field of anti-bribery and corruption. So I'm not usually front of house, but I've been through hair and makeup, so here we go.
Why are we looking at this particular case, Dave?
Well, it's quite an interesting case, and it's one that came up recently at an oil and gas conference that we attended as well. It's one that relates particularly to the differences and almost compares and contrasts some of the background to the Foreign Corrupt Practices Act and the UK Bribery Act. Now, in so much as it almost highlights the distinction between the two. The FCPA, as most of you all know, is a long-standing US-based anti-corruption act, and there was some guidelines issued to it at the tail end of last year. A big long document, really, to explain some of the nuances of the legislation. It didn't contain any new elements to it, though. One of the criticisms was that there are some improvements that some commentators think can be made to it. Now, the UK Bribery Act, by way of comparison, does have one of these elements that the FCPA could be developed upon, according to some of the observers out there. Now, that is a defence for adequate procedures. So, although both of them have extraterritorial reach, this is one key difference between the two of them. The adequate procedures defence relates to particularly the corporate liability aspect, in so much as under the UK Bribery Act procedures, if you can demonstrate that you have robust procedures, robust training, robust areas of recording, then it may be possible for you to mount a legal defence on that basis, even if somebody representing your firm is culpable for an action of bribery or corruption. However, there isn't such a thing currently under the FCPA.
Oh, okay. So what was in place at Morgan Stanley?
Well, Morgan Stanley were, of course, covered by all these international extraterritorial regulations. What I'm going to do, for sake of accuracy, is just refer to some notes I've prepared earlier. I mean, obviously, Morgan Stanley are a huge international company and take the issues of bribery and corruption very seriously. So they had a massive internal programme, as you would expect, where they made sure they had robust internal controls to make sure all its assets were accountable, and there certainly wouldn't be any offering, promising or paying of anything of value to any foreign government officials. As you would expect, these policies were updated regularly. They prohibited bribery, corruption, anything associated with the value of giving of gifts, business entertainment, travel, lodging, meals, etc., etc. Essentially anything that you could be culpable for under the regulation. And it wasn't just that they had the rules; they were very robust in implementing them, make sure they were being seen to. So they frequently trained their employees on the internal policies. I mean, the case we're talking about occurred in the Asia Pacific region and China specifically. And in the Asia region, between 2002 and 2008, Morgan Stanley had actually trained various groups of personnel there 54 times. So you can see they're obviously taking it very seriously. And on top of that, the compliance personnel would regularly monitor the individuals, audit particular employees, and keep an eye on transactions and business units as well. So there was a lot in place at the firm prior to this particular individual getting into trouble.
And what did Peterson do?
Well, Garth Peterson is the individual that we're talking about, and it's become quite a famous case study. Garth Peterson was the managing director of a real estate and fund advisory business of Morgan Stanley's in China, and he was a high flyer, I've read him described as, and essentially he was also part of the internal training programme. So the information available said that Morgan Stanley had trained Peterson on the FCPA particularly 7 times, and had also reminded him to comply with its rules 35 times. Unfortunately, Peterson didn't see fit to go along with this, and found himself involved in a deal whereby he wanted to circumvent the rules required in order to transfer a multi-million-dollar ownership to the interests of himself and a Chinese public official with whom he had a close personal friendship, else obviously becoming culpable under the bribery and corruption rules.
So what are the key learning points from all of this?
Well, essentially what we found out is that this is a good case to demonstrate the difference between the FCPA and the UK Bribery Act. Now, the reason for that is the outcome of the case was that Garth Peterson, he actually received 9 months in prison as a result of it. He was found personally guilty of attempting to evade the internal controls that were in place. But the important thing is that Morgan Stanley were found to be not liable. Now, as we said earlier, under the UK Bribery Act, there are procedures in place for having the sort of the defence of robust procedures, but under FCPA there aren't. So what this means to the practitioners is that by looking at this case study and really reading into how Morgan Stanley had done a very thorough job, how they'd been found not liable under the FCPA, however Peterson still was. And incidentally, as a footnote to that, we might be able to find out some more about it in the near future. As I understand, there's a book coming out inspired by true events, so we'll see how we get on with that one. But there we go. So in summary, yeah, it's a very useful case, and I'd encourage everyone to have a look at it because it certainly provides a lot of information into the controls.
Brilliant. Well, thanks a lot for that. Very useful and interesting stuff, and we hope our students find it useful and interesting too.
Thanks, Neil. Thank you.